Advisory Board of Indian Dispute Resolution Center. I welcome you all on behalf of Team IDRC and thank you all for sparing your precious time to join us for this evening. I would like to request the esteemed panelists to kindly grace the dais. Yes, sir. The Arbitrate in India Conclave 2022 marks the second anniversary of IDRC. We embarked on this wonderful journey in May 2020 when Honorable Mr. Justice AK Sikri inaugurated it. IDRC is a not-for-profit institutional arbitration center. It is registered with Ministry of Commerce and Niti Aayog and empaneled with Ministry of Law and Justice, Government of India. IDRC provides state-of-the-art institutional environment for online and offline resolution of disputes through arbitration, mediation, conciliation, as well as early neutral evaluation and expert determination. And it is conducted through our cloud-based in-house digital platform and through its affiliates in all major cities in India and overseas. Reposing faith in our celebrated panel of arbitrators and futuristic cloud-based e-ADR software, financial institutions including Tata Capital are on board with IDRC. The arbitration has had its firm roots in Indian culture for ages in the form of village panchayats. The first codification of the modern avatar was the Arbitration Act 1899. Then came the Indian Arbitration Act 1940, which was replaced by the current Arbitration and Conciliation Act of 1996, modeled on UN's UNCITRAL model on an international commercial arbitration. The Act came at the time when India's economic liberalization and latest amendments promised to aid in fulfilling nation's aspiration of becoming $5 trillion economy. India is striving to establish itself as an FDI hub, and courtesy statutory initiatives like Commercial Codes Act, Insolvency and Bankruptcy Code 2016, we have jumped from rank 142 in 2014 to rank 63 in 2020 in Ease of Doing Business report prepared by the World Bank. Powered by Justice B.N. Sri Krishna report, Arbitration Council of India is expected to lay down standards and make arbitration process more party-friendly, cost-effective, and ensure timely disposal of arbitration cases. Lately, the New Delhi International Arbitration Center Act 2019 has also been introduced. The biggest policy disruption which can bring a positive change is to institutionalize arbitration in the country. The central government is promoting institutional arbitration centers like IDRC, and such institutions are now ready to cater not only for domestic arbitration needs, but also for arbitration needs of South Asia and the world. A lot has been happening, but a lot can still be done to improve the position. Now I would like to introduce our esteemed panelists. Honorable Justice AK Sikri is former judge of the Supreme Court of India and is currently serving as an international judge in Singapore International Commercial Court. Although Justice Sikri needs no introduction, especially in today's gathering, as we all know he's one of the finest and most sought-after arbitrators in India. We are pleased to have him with us today. I would now request Mr. Sanjay Rathi, Advocate and Honorary Secretary of Bar Council of Delhi and Member Advisory Board IDRC, to welcome Justice Sikri with flowers and also present memento for the event. Mr. Balbir Singh started his practice by setting up his own law firm in the year 1998, which later on merged with DSK Legal in 2006. Mr. Balbir Singh was with DSK Legal as a senior partner for corporate competition and litigation practice till 2014. Thereafter, he started his independent practice. He is one of the youngest lawyers to be designated as a senior advocate by the Delhi High Court. Later, he was appointed as the Additional Solicitor General of India in the year 2020. I would now request Mr. Tanmay Mehta, Advocate and Member Advisory Board IDRC, to welcome Mr. Balbir Singh with flowers and also present memento for the event. Mr. Tejas Karia is a partner with the dispute resolution practice at Shardul, Amarchand, Mangaldas, and also heads the arbitration practice of the firm. Mr. Karia has extensive experience in handling broad range of complex, high-value international and domestic commercial disputes and frequently advises clients across the diverse industry sectors. He has also contributed to policy formulation in the domain of arbitration. He has advised on drafting of amendments to the Arbitration and Conciliation Act 1996 and Commercial Courts Commercial Division and Commercial Appellate Division of High Courts Bill 2015. He has also been part of the high-powered committee set up by the Government of India for institutionalization of arbitration in India. I would now request Mr. Divyan Chanu Rathi, Advocate and Member Advisory Board IDRC, to welcome Mr. Tejas Karia with flowers and also present memento for the event. Okay, sir. Ms. Vanita Bhargava is a senior member of the dispute resolution team of the coveted law firm Khaitan and Company. She has around 20 years of experience in domestic and international arbitration, as well as a variety of other legal fields, including constitutional law, taxation laws, corporate laws, banking laws, and insolvency matters. She is recognized as one of the top 15 disputes lawyers in Asia by Asian Legal Business based on her exceptional work, client feedback, and market recommendations. I would now request Ms. Janvi Rathi to present the flowers and the memento to Ms. Vanita Bhargava. The moderator for panel discussion, Mr. Sanjeev Srivastava, is a senior journalist. He has been group editor and head of a number of leading news channels and media houses, including BBC, DD News, Times of India, and Indian Express. I would now request Ms. Sumedha Sindhu, Advocate and Member Advisory Board IDRC, to welcome Mr. Sanjeev Srivastava with flowers and memento.
Shine through in the next 45 minutes or so. And the other thing that I wanted to say was that journalists, even after work, nobody has paid for quite some advance fee. So please participate in the proceedings, and thank you, and please bear with me. Thank you very much.
Now please allow us to play a short audiovisual on IDRC.
This is where the Indian Dispute Resolution Center comes into picture, whose name itself gives a basic idea about its functioning and purpose. IDRC is an initiative of international Rules 2019 and the IDRC Conciliation Rules 2019. IDRC Arbitrators. IDRC maintains an in-house panel of esteemed arbitrators and mediators, which include former judges of Supreme Court of India, Chief Justices of High Courts, judges of High Courts and District Courts, as also senior advocates, Queen's Counsels, chartered accountants, company secretaries, architects, ex-PSU's heads, bureaucrats, corporate leaders, and the like. Empanelment positions are offered only by invitation to the best dispute resolution professionals available in the country and other parts of the world. eADR software. IDRC has India's first of its kind online eADR facility hosted on secure cloud servers, conducting arbitration, mediation, and conciliation. IDRC's eADR portal has following major components: personal dashboards, e-filing, e-booking, e-payment, virtual hearings, cloud servers with 24/7 access, e-allocation, e-notices, digital signatures, e-certified copy. Types of disputes we resolve includes commercial dispute, property disputes, financial services disputes, public sector disputes, international commercial disputes, building and construction disputes, matrimonial disputes, banking disputes, IDRC's virtual ADR hearing. IDRC's virtual ADR hearing portal is hosted on world's best secured cloud servers and manned by trained professionals. Its salient features are 24/7 online booking platform, facility to have up to 100 participants, secured with end-to-end encryption, breakout rooms for private consultation, licensed multi-channel video conferencing software, pay-you-money secure payment system, HD video and Dolby voice quality, technical support, option to record and preserve the hearings, secretarial and transcription services, functional rooms. The center comprises of several rooms, of which include arbitration mediation room and consultation room, apart from the waiting area. The space is suitable for conducting arbitration, mediation, conciliation hearings of various sizes. All rooms are equipped with latest high-tech communication and multimedia gadgets. High-speed, state-of-the-art video conferencing facilities is available in all the rooms with HD video quality output and end-to-end encryption. The IDRC can advise clients on court reporting services ranging from same-day transcripts to real-time reporting services where you receive a live feed on your laptop. We can also assist you with your deposition requirements. So resolve your disputes today with the IDRC like never before. Indian Dispute Resolution Center, helping good people resolve.
Conditions. This conclave is being organized to bring to the fore our nation's strengths and challenges in becoming an international arbitration hub. The conclave will ponder over the theme Arbitrate in India to strengthen the government's call to resolve in India. It is my honor and pleasure to welcome you all, and now I would like to request Sanjeev sir to please commence the panel discussion. Thank you.
Thank you very much. Thank you very much, ladies and gentlemen, also for being here this evening. And thanks very much to IDRC for giving me this opportunity and a platform to engage with such luminaries, people I had only read about and seen. So I'm sure I will be duly enlightened in the next 45 minutes or so about a subject on which my knowledge is limited to last 24 hours, so to say. But we all have been arbitrators in some ways, or mediators, or conciliators all our lives. So now, if we juxtapose the world of arbitration and the conciliation with what is the Indian story, or India's story, especially in the last few years, the government, and we all know, talks so much about how India has jumped so many ranks from about 190 odd countries. It's now ranked 63 in ease of doing business, which is a huge leap for India. But one of the key things of doing business is enforcement of contracts, legal issues. We just saw in this presentation, I think 73,000 was the figure given. I think the number must be much higher about the cases pending in the country. No, but that is just arbitrary. Okay, only Supreme Court, right.
Yeah, about 44 millions in other courts.
Yeah, 44 million, right. So it's even difficult to imagine the number of zeros there. But we have lived with this problem, and hopefully arbitration will solve this, because in this enforcement contract, we are in the bottom 25 in the list of 190 countries. So, Sir Justice Sikri, if I can begin with you, you have spent virtually a lifetime in this world of justice, jurisprudence. How do you see and where do you see India and our situation right now in this committee of the world of arbitration, conciliation, mediation? Where are we? How do we go forward?
See, I think that
I
think that's a central theme of this discussion today. Uh, and when the topic is resolve in India, insofar as domestic arbitrations are concerned, they are to be necessarily resolved within the country. So therefore, what I presume is that when we talk of resolve in India, we are talking in terms of international arbitration. As I said, domestic arbitration, those disputes are there, then we will have, in that case, both the parties would be Indian parties. Normally, arbitrators will also be Indian. So resolution takes place within India. Now, this question has come up for last, and it is now being discussed, particularly in last 7 to 10 years, very vigorously and hotly, I would say, and very passionately as well, that how to make India as a hub of international arbitration. And I would say here, and going by the theme of today's discussion, it is not limited to, and the objectives with which IDRC has been established. It's not only the arbitration, but we are talking of all ADR forms, which includes mediation and conciliation as well. You see, for this, if I may say in very limited words, that in the beginning, and when we talk of international arbitrations, what we are thinking is those disputes which have these international flavors. That means it may be one Indian party and one party which is of other country, or it may be parties belong to countries other than India, and they want to resolve their disputes by coming to India. That is the topic, and that is why I say resolve in India. Now, if I may say this, that it is like legal tourism. We have health tourism. And what happens is that many persons from other countries, they come to India for, on account of health issues. But then they think that no, it would be a good thing that not only have the medical treatment here, we'll be able to go around as well. So that is why we call it health tourism. So whether we will be able to have that kind of environment that we create legal tourism, which as of now, many countries, and in particular in Asia, Singapore has been able to do it, and has been able to achieve it. So what it takes to go there, going by example, Singapore example, or before that even Hong Kong was there, Malaysia also achieved some success in past to some extent. Dubai is also trying to come up. I'm talking only of Asian countries. The main thing which is required is to create that kind of environment in India which is arbitration friendly or ADR friendly, if we talk of entire ADR. That is how we will be able to. For various reasons, as we know, in this presentation also it was quite depicted and very vociferously it was mentioned as to what they want to do, and the significance of arbitration or ADR, whether it is mediation or arbitration, that it has to be cost effective and it has to be speedy. And you added to that contract enforcement. And here when we talk of contract enforcement in the context of arbitration, we can say enforcement of arbitral awards. So whether in all these fields, we have been able to create that kind of environment that the people from other countries come. There I would say that is lacking as of now. We have not been able to. And that is what we need to do. I will only, in my preliminary remarks, I will only end with this. Of course, what should be done and all, we can discuss that. Again, going by Singapore example, that they have created this institutional trinity, which I may call it. It is SICC, SIAC, and SIMC. SICC is Singapore International Commercial Courts. That is for international purposes, international disputes, commercial disputes. You can go to court if you want to go. So that will be decided by the courts. In India, we have commercial courts as well, but those commercial courts are deciding only domestic disputes. There is no such thing. Then they have SIAC, Singapore International Arbitration Center, which deals with international disputes. IDRC, let us hope that it is able to come up to that expectation in few years. And SIMC, which is Singapore International Mediation Center. So therefore, they, in order to create that atmosphere, what has happened, as I have studied in last 15, 20 years, that arbitration is a hybrid system, if I may say so. It is, of course, party autonomy, where the two parties choose to appoint an arbitral tribunal of their choice, not the courts, because in court when you go, you don't know where your matter would be fixed, which judge will hear. But here you know these are the arbitrator and I am choosing the arbitrator, so that's called party autonomy. So that party autonomy is there, but at the same time, even when there is a party autonomy, the court's function still is there in arbitration process. That is why we call it hybrid system. In the beginning, for appointment of an arbitrator, if arbitration agreement doesn't say you have to go to court, file an application under Section 11. During arbitration, many times you have to go to the court to for the assistance, like for summoning of witnesses, etc. And after, as I said, when the award is given, for enforcement of the award or for challenge that award, so court role comes. But what kind of role that should be? It should be only supportive.
And that's something we have to discuss going forward.
Yeah, going forward. Right. So what I was only, my preliminary remarks were that we have to create that kind of environment. Of course, that has been, and we'll come to that, as you say, where the stakeholders are comfortable with that conducive environment is there in India and we can come. So that would be my.
So that is the world of utopia we are all aiming for, that one day it will happen like that. So Justice Sikri just mentioned or gave the example of Singapore, a country which has successfully proved over a period of time and again that small is not just beautiful, it can also be hugely successful. So how do we go forward, AG Saab, Balbir Singh ji, on this front, that how do we make our this dispute resolution system more effective, more powerful, more meaningful, good interventions? I know you don't technically represent the government in this domain, but you are our government person. So what I would like to know that, like whether it's in medical tourism, we are doing quite well. In any industry you see, Indians really outshine everybody across the globe. Similarly in arbitration, it's not just in software or banks, even in arbitration, Indians tend to do superb. You know, best cases in the world are decided by Indian arbitrators. But in India, there is no such institution, and India also has the, I would not say dubious, but rather not very happy distinction of losing a number of high-profile arbitration cases of late. So, what in your opinion, sir, should we do? Why this happens? How do we address this problem? And just before I leave you with this question, other than Justice Sikri, sir, who is such an eminent person and senior to me in age also, sir, with all respects. Others I'll be happily interrupting. So you don't, no, sir.
Your
no,
journalist
sir,
instinct is not going to, you're not going to give up your journalist.
And also I will request the other panelists to, if they have a point, they can interrupt each other, because let's make it interesting for the audiences. That's the idea. Yeah. Sir.
No, I think I can tell you first about you talking about the medical tourism. I recently had a conversation with Justice Sundaresh Menon, who's the Chief Justice of Singapore High Court. And in the context, Justice Sikri's name came in, and he's considered an arbitration doctor, I can say for sure, not related to Indian arbitration. So he's very, very well respected in the international arbitration. And I can say with certainty that a lot of people are chasing him in the international arbitration to appoint him. And I'm sure his diary, if you today look at, you will not get the date till 2023. So it's not that the only Indian, not only the Indian doctors who are very well respected, but our judges and the arbitrators are very, very well respected. So I think, and that's one of the fundamental parts to make any institution which is highly respected. But I think on a broad spectrum, if we talk of, you must have heard that the India want to be a 5 trillion economy in next 5 years, 10 years, whatever the time frame that is. And I think the dispute resolution is one component of that economic activity which will finally result into achieving this kind of number the government is looking at. And the basic premise of this is that India, being a capital-starved country, is dependent on a foreign capital for a lot of development which is anticipating, which finally may result into at some stage in a 5 trillion economy. Today, the capital is very clear, is going to go to that part of the world which is going to earn that capital a further number. If the capital is stuck in any country, I think the capital which is flowing in the world is not going to go to that destination. If India want to achieve that 5 trillion, the resolution of disputes in India at any level is a primary objective which is going to contribute to this, and government is very, very conscious of this part. Now, coming to this, how do we do it? So far as the international arbitrations, primarily if we talk of domestic arbitration in India, we already have in a domestic sphere. In international arbitrations, I think Singapore is a small country. The focus which they have given to create that we are a fair, transparent institutions we are creating. The stakeholders, like the arbitrators who are there, people have great faith in those arbitrators. And most importantly, I think the participation by people around the world who are highly respected in the pool of arbitrators is a great attraction, which is the one component I see that today when you go to International Arbitration Center, besides the physical facilities like Maxwell Chamber and all, a list of arbitrators which are globally very well respected and where we see Justice Sikri's name being there. I think that's one of the component which is there. Second part which I see that any institution, until unless it earn a name for itself in the form of an institution, people chasing institution, the stakeholders are very important. The second stakeholders are, when I see we have 2 other panelists who are very, very well-respected participants in these arbitration proceedings, which means that people from around the globe are free to participate in these arbitration proceedings, so that if the QC from London wants to come in and appear in the arbitration in India, there should not be any impediment that may be from the residency standpoint, tax standpoint. So there should be a facilitation to allow these kind of stakeholders to come in. We have and the same, we see that I think Tejas and you've been appearing in most of the international, and I don't think it ever comes to your mind saying that you will have any issue when you're representing. So I think the environment has to be conducive, which will be created. And the third component I see beside the stakeholder is the facility which is to be created. I hope that we have more IDRCs and which are larger in terms of facility which is being created across the India, which is offered to the foreign participants who are investing in India. I think broadly, if you look at these 3-4 parameters, then the interplay of courts, because it is not that you are completely isolated from the courts. So I think as a courts also need to play a positive role, which I see in last 10 years. Whatever the amendment we have seen, the Arbitration Act, we have seen the creation of the commercial courts in India and places like Delhi. The speed has gone up. The interference in the final awards have certainly reduced to great extent. We do not have any more 34s which are stuck for a very long time, but broadly that's here there. And one more recently, because I participated in 2 weeks back, this issue came in about a Section 11, which means that you need to go to court to appoint an arbitrator. And when the court realized that this is 2014, somebody disputed, came to court to appoint an arbitrator. So Justice Amarchand said that please call all the high courts and call for a list that, yes, recently it was there. So when we realized that for appointing an arbitrator, which is the first step to resolve a dispute, if the matter is pending for 6 years, then the dispute certainly, I think, becomes meaningless in terms of the idea of achieving a shorter period. Dispute resolution is defeated. So I'm saying the court is also conscious, and the High Court have been specifically instructed to take care of these kind of things. I think broadly interplay of these, the stakeholder, the institutions being created, and our courts being sort of aligning themselves with the process we are trying to achieve or a objective. I think this is broadly, I see the way forward. and to achieve a larger objective where the government is seeing that it plays an important role in creating a 5 trillion economy. That's broadly the overview I have on the situation.
Great, great. I'll come back.
Sure.
Just taking up from where Mr. Singh left, or one of the points he made was this issue of when he was referring to this judgment of Justice Amarchand and this issue of appointment of arbitrators, because as I was going through my little notes on this issue, I also realized that the process of appointment of arbitrators can also take years. So the whole point of having arbitration instead of litigation to hasten the process gets defeated in that sense. And the other thing which the terms really baffled me a lot was this ad hoc versus institutional arbitration. So Vanita, can you please throw some light on these two issues with your rich experience? Like it was mentioned here, you have been appearing for such a long time. So how do you understand this issue and what is your take on this?
Sure. Traditionally, we have been plagued with many issues in arbitration. One was timely disposal of the arbitration proceedings and the cost of arbitration. So with the amendments, we have seen that these issues, many of these issues have been addressed. And so these two issues really distinguished ad hoc with institutional arbitration, why somebody would choose to, to reduce cost and for timely disposal. But having said that, I mean, the amendments have shown that the government clearly is trying to promote institutional arbitration, and there are many advantages of institutional arbitration. For example, in commercial arbitration, and now with technology really catching up, so many technology contracts, institutional arbitration can help in dealing with these arbitrations, dealing with these, these issues which require experts. And then we saw what IDRC also showed, that they can have a expert panel of arbitrators, from a larger pool. And what Balbir also said, that if now I think with the 8th amendment being removed, even foreign arbitrators can also be included, and that would actually really build up the importance of this institutional arbitration.
Automatically go if they are institutions. Because one goes straight away, applies to the institution, and within a couple of days arbitration can be started.
But why do foreign companies or foreign firms would like to engage more overseas companies or overseas firms only? What is it that is lacking here that they won't like to really engage or involve local players in a big manner? And you can be very frank.
I feel that if suppose there is an arbitration where an international party is involved, they have been working with those firms, maybe, and those firms have a larger reach. They must be in all jurisdictions. As such, Indian firms really have not really spread that far. So when any party is comfortable in dealing with that, and so therefore, even in the Indian scenario, that is one reason why they might want to engage, or it's just the comfort factor. But if we if we bring out if we bring out these changes, and now even it's not yet been notified, but those amendments that now arbitrators can be appointed by the arbitral institutions, courts can. So this if you expedite in all these areas, then I'm sure it is going to get better. They're not.
The other thing which I really want to understand, and Tejas, I will come to you, and this is just how we are sitting, that I'm coming to you last. Your eminence and the work your firm is doing is known to all of us. So why is it that we, which I mentioned, that raised that point just now with Mr. Singh as well, why is it that we are consistently losing these very high-profile cases? Is it something wrong with our government decision making, or is a legal framework lacking? Not framework, the lawyer side of things, or arbitration, whether it's Keynes or Vodafone, there's some very high-profile setbacks. So, and you were involved with them. So I just want to understand as a layperson as well.
Because Tejas is appearing on the other side.
Okay, right. Okay. Yes. So you are maybe not the correct person.
No. I'm
please.
happy to
certainly a
answer.
perspective
Yeah.
on it. This is not like
That's
this.
But
perfectly fine. No, see, in India, we have to see that we have changed the ecosystem in a large extent in last 7 to 8 years. And the things have changed considerably in after 2015 amendments. And we have plugged all the loopholes. So I don't think that as far as the commercial arbitration is concerned, we are far behind than the other countries. But the only problem I face, and that I have been advocating, is that India can never become hub of international commercial arbitration. India is a country which is very large, and you have so many diversities, you have so many judicial disciplines in different parts of the country. What we are comparing ourselves is with Singapore, London, Paris, Hong Kong. All these are cities. They are not countries. You may have a country which is city-state like Singapore, which has their own legislation. So we need three things basically. First, we need the law. The second, we need the support from the court. And the third, we need the arbitral institution. And if we have to compare ourselves with Singapore, then we have all three. But in the size of India, that can never happen. So what we need to do is that identify cities in India which can be the hub for international commercial arbitration. And that is where we have to focus in cities where the court is supportive of the arbitration, or the arbitration-friendly jurisdictions are there. And what we need to do is have judges who are either trained or experienced in arbitration to handle those kind of matters. We don't have to go to court for appointment. If you have institutional arbitration, as Justice Sikri and Vanita mentioned, the appointment is done by the institution. I am member of the Court of Arbitration of SIAC. Any arbitration where SIAC is the institution, you don't have to go to any court. So court is out for Section 11. Then for interim relief, you go to emergency arbitrator. Emergency arbitrator is appointed within 48 hours, not even including Saturday, Sunday. So we have appointed emergency arbitrator in 48 hours, and within 14 days you get the final order. Which court in India can compare with this kind of speed? And the fees is fixed, so you don't have to worry. So emergency arbitrator's fees is fixed. You are knowing that within 14 days you will get the order. Again, that order is enforceable as well. The courts are recognizing those orders as a final order. So that way we have to change our mindset of having to, or aspiring to make India as the hub. It's quite difficult. I would say that we have to take smaller steps and make, I would say we should copy DIFC, and GIFT is one example where we can have the court, we can have the institution and the infrastructure. IDRC is doing great job, and we should definitely try to imbibe those cultures where we have seen the success, and we can definitely copy that. Now, coming to the investment treaty arbitration, that's the question you asked. See, India signed so many bilateral investment treaties, and that was to give protection to the investors coming to India, because we always wanted to be investor-friendly jurisdiction, and also give protection to Indian who are investing in those countries. It was bilateral. So it was very equal treatment which we used to give to the investors in India and also the Indians who are investing outside India. What happened is that somewhere we could not anticipate that we can have claims for not doing our, so the white industries was a great example where there was a delay caused by Indian court. Now, who could have imagined that we can be sued for bilateral investment treaty? And then also retrospective amendments to the text. Now, in the new BITs, we are removing that. But those are the examples. We have learned a lot of lessons from that and tried to improve from those lessons. So there are these exceptions where we have lost, and the government and all of us, we have learned from those examples. The thing is that we have to improve our system. In the speed of justice delivery system, we have to really ensure that we don't have so many delays. Of course, it's a vicious circle. We have lack of number of judges in the court. We have so many other issues, so the commercial issues take a backseat. When I went to National Judicial Academy, Bhopal, to talk to High Court judges, and we had judges from every part of country, and I was talking on arbitration, everybody listened to me very carefully, and then after a point, they got impatient and they said, why should we give priority to arbitration? What is so special about arbitration?
Yeah.
There are people who are in jail. Why a person who has invested in in India and who is a foreigner who can wait for 5 years, and somebody who is in jail who is languishing, why should we not hear that case first? I said, I don't have an answer to that.
I think Justice Sikri would have something to say on that. But to put it more succinctly, that's perhaps one of the reasons why, with your permission, sir, judiciary should be maybe completely out of arbitration. Or what is the way forward? As far as judicial intervention is concerned, the role of judges, which is so important because nobody understands law better than them in some ways. But at the same time, that makes the process slower because they just know things so well.
Yeah, what Tejas said, this is very pertinent observation he has made. I may add one thing as far as BIT arbitrations is concerned. We read in the newspaper only 4 days ago, we have won one case.
Okay, great.
So it's not that, and there are other examples also.
Yes.
Of course, White Industries was one, Vodafone, other, and White Industry also, as you rightly mentioned, award was in favor of White Industries. So even arbitral award was in favor, which was challenged, which was pending in the court. And since that was taking time, so they, and this arbitration award was normal arbitration. So then they initiated under BIT.
I'm sure we are going to win many more. It was not at all
so there
my
are,
intention
there are
to
many
put our system down, but just pointing to the obvious.
What I'm trying to say is, no, those awards were international awards, so not given in India. And whether the first award or even that came only for enforcement. And even the second was under BIT, so that award was given. And interestingly, this was challenged on the ground, although we say that matter was pending for quite some time. This was one of the grounds for raising a dispute under BIT, that look, matter is pending for last so many years, languishing, and the Indian courts are not that efficient. Interestingly, that ground was shot down, was not accepted. But still under MFN, most favored nation clause, they went ahead and they said that we have the jurisdiction. And it raised another kind of disputes. I just wanted to complete what it raised another kinds of issues. Now, on the one hand, there's an arbitration award given in White Industries, which is under challenge. It is pending before a court. And of course, this is a judicial function is a sovereign function. What would have happened had that award been set aside by the Indian court on whatever grounds? So therefore, could you scuttle the process which is already initiated and the matter is pending and to go under BIT? That was one of the main reasons for government to have a rethinking. And in those days, and that also happened 7, 8 years, I think White Industry, much even more 10, 12, 13 years ago. And 1 or 2 more such cases came up, and therefore the government decided, and it scrapped all BITs. Of course, sunset period is too large. Yes. And therefore, even the disputes which are arising even now will still go under BIT, we have to be resolved. And they have come out, as Tejas has said, with another BIT regime, and many countries have signed, many have still not signing. They are saying that no, it is loaded in favor of India, why we should accept and all. So those issues are there. We are not talking about those issues. But coming to this, what Tejas said, and on that you asked that question. Look, in India, there is a problem of arrears. As you found, 44 million cases. Of course, 75,000 are in the Supreme Court, and this figure of 75,000 has gone up in 2 years from 50,000. So 1.5 times more because of COVID only in last 2-3 years. I remember when I retired, it was around 50,000 only 3 years ago. And as far as district courts are concerned, figure was 30 million, which has gone to 44 million. And of course, out of this, about maybe 50 or 60 lakhs or maybe 70 lakhs in the high courts. And the courts are supposed to deal with all kinds of cases. So therefore, that problem has to be tackled. We have to, on one hand, as we are talking about ease of doing business, We are talking about FDIs, etc. in this country. So we have to create that, and it was said by
there
our
are other life
solicitor
and death issues
that
like
5 trillion economy, and that cannot happen. This was a very pertinent observation made. Cannot happen unless contract enforcement is there. So therefore, this area has to be taken care of, no doubt about it. But at the same time, other kinds of cases, and particularly those languishing in jail, etc., family disputes, those are also very important. And here in India, all judges are, we are all generalists. There are no specialists. So every judge is supposed to decide every kind of case. It's only today I am sitting on criminal jurisdiction. After 6 months, I will go on commercial jurisdiction. Then I will go on, say, writ jurisdiction, etc. So therefore, the question that arises in these circumstances, in first, if we want to create commercial courts, we have, like in Delhi, Bombay, commercial courts are successful. But then commercial divisions are there, commercial courts are there. So we want so the judges who are dedicated to this, and we are able to spare judges for this. In order to have it, overall number of judges have to be increased. Now, problem
But sir, should we not appoint the judges who are expert?
That is the second thing I was coming to. Secondly, like those judges who made that observation, with due regard to those judges, of course, I don't say that the cases, the persons who are languishing in jail, their cases should not be decided. But then you have to maintain some kind of balance. You cannot say, okay, and I am very frank in saying so, many judges have this perception. Why take care of, these are rich people, these are disputes of, as he said, persons from outside who have come and invested the amount and money here, why they should be
But truly
given
speaking,
preference.
those disputes actually affect everyone,
Yeah,
including
exactly.
the not so rich.
So therefore, we need specialist judges who should have, who are having a proper outlook how to, because commercial disputes are not, they have impact on the economy. I have said as a, one of the judgments that as Supreme Court judge, that there is a deep and strong connect between the law and economics. And even when judges decide those issues which have bearing on the national economy, they have to be careful how to decide. So that kind of mindset have to be there, that kind of expertise have to be there.
With all respect, sir, sometimes the pronouncements completely baffle me on so many things, because it's like you are saying judges are journalists. Journalists are actually journalists. But still, sometimes when journalists also pontificate on things which they really don't comprehend so well, it gets very difficult. Judges, of course, do apply their mind in more detail, but maybe they should go more to experts. What I want to ask you, Mr. Singh, and we'll round this up in another 8-10 minutes maximum, because I would like to throw it open for the audiences if they have any query in mind. So why, when we know the problem, why is it that the government and people like you, sir, hesitate in getting arbitrators more often than going to courts in the regular legislation, litigation going on? Why shouldn't the government be more proactive? Do you agree with that perception, one? And is there a way out of that?
No, I think first, you need to understand that the choice of adopting a mechanism to resolve a dispute is between two contracting parties.
True.
So if the two parties, and particularly you're talking of in context to the government, if we talk of government companies, PSUs which are there, if they have adopted a dispute resolution mechanism, not going to court but to the arbitration, so that's a start point which happens. If that kind of option is not in a private contract, which means we go back to the court. So demarcation is very clear that the arbitration is a choice by the two parties, that we don't want to go to court and we want to resolve a dispute through an alternate mechanism.
But only, I'm sorry.
Yes, yes.
As he said, you should, you can. But let me tell you, as he's about PSUs and all, maybe almost 90-95%, maybe almost 100%, there is an arbitration clause insofar as commercial disputes are concerned. So government that way is preferring arbitration and even mediation also now. It's not that government wants to go to court.
They are not
only.
having institutional arbitration.
And so
So
That's the, I think I was
that's
coming
the
to
only
that.
problem.
So
Yeah.
the issue is because as on today, as Justice Sikri said, in the commercial contract, there is an arbitration clause. Now coming to this baffling question of institution versus the ad hoc arbitrations. If it is not specified that they are opting for any institution to step in and to resolve a dispute, which we call institutional arbitration, which means that anyone appointing who's got the authority to appoint an arbitrator, if they fail to appoint, then the court can appoint. So that's a random or ad hoc adoption of arbitration or dispute resolution mechanism and a person who's been appointed. Now that's the one area which sort of has taken time as courts have stepped in, maybe at some stage, maybe at the initiation or the later part. I think that's one area you're very right. And it's not the government is not trying to do something. So there is recently I can tell you a committee has been formed for PSUs that to review these contracts, that at least for the future contracts, we should have certainty of 3 or 4 things in a dispute resolution clause. That are we opting for ad hoc or institution? We do not leave it open. And we should go by institutional arbitration, maybe a Delhi or maybe the IDRC being appointed as institution. Once that part is made clear, then at least this is taken care that how do you appoint, who's going to appoint, that controversy of going to section 11 and the courts appointing and then further being challenged. That is being addressed, and there is very soon you will find there is going to be a model clause which will be there in a certain types of contracts like NHAI. I'm sure everybody would have faced at some stage the other. NHAI is the largest litigating party today arising out of the arbitrations in courts. So that's the first step which has been taken, where I think to rehauling this arbitration clause for NHAI. Second is to prescribe the certain set of or a pool of arbitrator to resolve these construction contracts or infrastructure contracts. That's where the government is second working. I hope we'll see something very soon for these large infrastructure companies and NHAI in particularly. And third is a very big concern has always been that if there is an adverse award against the government entity, whether to pay or not to pay. And we have seen cases where they have lost, which means the award is against them. Matter is in going to a Supreme Court in next 10 years, then the interest amount is much more than the original award. There's been a constant problem. So government has come up that even if there is a view or a legal view has been taken that there is a merit in challenge to the award, still please pay 75%.
So that at least you save on the interest.
Exactly. So Niti Aayog circulated
and
this to the most
doesn't
of
go bankrupt meanwhile.
Yes, and the one more aspect, exactly, one more aspect which the government has added is that before going to arbitration in these large infrastructure contracts, you should have a board to resolve a dispute. And if the board also is deciding against government in that case, please pay 75% at that stage, even if you want to go crossover, because the decision of the dispute resolving board is not binding, still you can challenge and go in arbitration. So the government is conscious, it's taking time. I mean, I understand that it's taking time on this aspect, but this is certainly in know of the government, and there are certain processes which are being on. We hope that in times to come, we see that at least these things are taken care of in a large litigating areas arising out of the arbitration.
And as far as these board are concerned, what he said, DRB, which
DRB,
is called
yes.
normally, I have seen my experience in many arbitration. Naturally, if the decision of the board is against the contractor is not going to accept, it will go for arbitration. But most of the time, even governments or PSUs are not accepting. So what's the use of that board? At least, and where it was a board constituted, one representative, it's like arbitral tribunal, one representative of each, and third is also theirs. So out of 3, 2 belong to government. They are saying government, no, you have a weak case, pay, and still they won't pay.
So there is
And
a
that mindset
problem.
has to change.
No, there is a serious problem because who will melt the cat is the
Ah,
problem.
yeah. That's
So therefore, there is a suggestion is that the government can consider forming a kind of a advisory board who takes the decision on behalf of the government organization rather than making the officials to take a decision. Because we have seen not only at the initiation of arbitration, at 34 challenge, 37 appeal and SLP. There are 4 decision points. And we have seen that nobody wants to take a decision because they have fear of CVC, corruption.
Yes.
So therefore, we should take away that power or the obligation, I would say, from the officials or the law officers who are taking the decision.
No, but I have seen
and
now,
give it to, say, former
right,
judges
and
of Supreme Court or High Court.
Yeah, many are now taking opinions from, they want on panel some retired Supreme Court or High Court judges, they would give. But how far
But
it is
sir, this is
successful,
different
I don't
from
know.
opinion and a decision, because after opinion also the decision lies with that
Correct,
official.
correct.
Okay,
So
I'm
there
sorry,
was a
I'm just
suggestion.
going to interrupt. And thank you very much, ladies and gentlemen, for your patience. We'll just round it up in another 2-3 minutes. And then you can ask some question. Vanita, you save your energy only for the courts, I think, or for your clients. So my question to you, like they just suggested that maybe we should have city-specific models like Singapore or Hong Kong, which are smaller places, or there have been other ideas coming up. What do you think is the best formula or model which would work for India? Which size would fit our shoe best?
Like what Tejas said, we can start small, but start with the cities. And of course, like we have discussed, that it is not just one aspect of having a good institution. As a, it has to be that the courts are also very proactive. So it depends on the cities. I mean, we can start with the metros, which has already been happening, that there are good arbitral institutions which have come up. The courts have been proactive. So similar, once you develop that model in these 4 big cities, it can be, taken to the other cities. And especially where, it is all to do with where investment, the government is seeing that there is more investment. Such cities can be targeted to develop robust institutions, and the courts, like we spoke about, training of the judges. So such courts can be targeted where trained judges can be posted.
I remember about 10 years ago there was a discussion, I was sitting there at that time, that why not develop Delhi as a model like Singapore, city, state, and we should have infrastructure also, we should have legal tourism, as I said, also of the same nature as Singapore. So
They
let us
can go
start
to
with
Agra
the
and
example,
Jaipur.
and let us start with Delhi, but it didn't happen for whatever.
No, I think the one interesting I remember, and sir, I think you participated in that, when Justice Sundaresh Menon called a couple of countries like Malaysia, India, Singapore, and 2-3 other Asian nations. They wanted to create this common court, which means that even a domestic dispute could have gone to their court, which required a modification in our law, but I think that has not progressed. But I think Singapore has gone to the extent of saying that you can outsource your domestic dispute resolution to the Singaporean courts. So I think it's a mindset issue broadly, somebody at that level. Yeah,
They want our domestic disputes also to be resolved in their court.
yeah, if it's a large
Look at
value
their-
dispute, the two
this is
parties
what-
can go, yeah.
The really cheeky ambition, but and also competence to some extent.
Create an ecosystem and you have users. So
Yes,
it's entirely.
So just before I throw in to the audiences, and more or less you have answered that question also, but it's more like a cliche thing to end any discussion. So what would be the top number one takeaway for you as how do we go forward? If we can start from that side and end with Justice Sikri. Tejas.
So I would say institutionalization of arbitration, use of technology, and reduction of the court, use of court for arbitration. You go to court only at the extreme cases. That's the big 3 takeaways, I would say.
Great. Vanita ji.
So I would say that how the government has been so quick in making the amendments, seeing the problem and trying to control the mischief. The same thing should continue. That and also less judicial intervention, and maybe specialized courts. Even commercial divisions are there, but maybe for arbitration, because the commercial courts are also handling other kinds of commercial matters, which takes away the time. So yes, specialized arbitration courts in the commercial division.
Right. Mr. Singh, you did suggest actually quite
No,
a
I
few.
think one is I would say the trained pool of arbitrator, domestic as well as the foreign arbitrators. I think that's the one thing which can really add a lot of value in the Indian system. And second, again, the trained representatives, which mean the foreign lawyers coming to India, and Indian bar. Because as on today, what I see is that we go to court, and after the court hour, we go for the arbitrations. So I think we may say that we have a separate arbitration bar, but the specialists, like 2 of them who've been there, we need more people of that nature. So the pool of, on both sides, the arbitrators and the representatives in India need maybe a foreign QCs coming from India. I think these 2 can really add a lot of value. I personally see that if they can be there.
True.
Justice, sir.
Yeah, what I feel is that we need to take small steps. And you just in one day's time, you can't think that the Western countries they would come and they will look forward to India as an international hub. So why not start with, say, South Asian countries? Now, we may have good arbitration center in Singapore or Hong Kong, etc., but there's nothing like in our 6 or 7 countries around India.
Yeah.
So once we start with that, they look forward. Actually, just now received, this was one call from, for last 2 days, one judge from Bangladesh is calling me for some conference.
So maybe we can have a SARC
no,
arbitration
yeah,
center.
exactly. SARC or this kind of, and if we are able to show our worth and we are able to show our mettle and we are able to demonstrate to the world that look, we are successful, then it will spread to other countries as well.
Yeah. True, if we can become a successful model for our immediate neighborhood, that would be a big thumbs up and building stone
and
as
it
well.
would be easy to catch that. That catchment area is quite easy.
So with your permission, can I throw it to the audiences if they have any query in mind? A few questions. We will keep this for 7-8 minutes. Yeah. Yeah, please.
Thank you. And one more mic.
Yeah, please take this.
Thank you.
So there will be some will be pointed here.
Good evening, sir. I'm Anil Gulati. I retired as an additional secretary. I was mission director for National Mission for Justice Delivery and Legal Reforms for 5 years. That dealt with the problems relating to pendency and all during that period. Sir, we had a scheme where we used to allot projects to various institutions for improving the judicial outcomes. And under that scheme, we had received a project from IIT Kharagpur. And that project wanted to use artificial intelligence for decision support system in judiciary. But at that time during the meeting, there was a lot of resistance from the Supreme Court representative. They don't want. Because basically in the sentencing part of the judgments and the lower courts, there was a lot of variation for the same kind of offense. So they wanted that there should be some consistency. And in the cases you are mentioning, during my time there were 30 million cases when I was there. Now there are 44 million. But I found that most of the cases like traffic challan, shop and establishment, very small matters. Why should the judicial time be wasted for those cases? Why not artificial intelligence and other such things take over?
You made your question you put it very well. So we can stop and allow somebody to answer. So
Thank
we can have 2-3 more questions.
Thank you.
You see, actually, as far as introduction of artificial intelligence in judicial system is concerned, this is altogether different aspect. Doesn't deal with, this topic which we are discussing. But having said so, you are right. It's becoming a challenge now, and it is projected, at least in America, that in next few years, 70% works of the lawyers will be taken over by the artificial AI system. Now, therefore, today the challenge is that as far as AI is concerned, it should not substitute either the lawyers, legal fraternity or judicial system, but should be a supportive. So how that is to be achieved, there are great debates going on, not only in India, everywhere. Now, so therefore we can use, and if you remember, even when Justice Bobde was also appointed, the day he was elevated as Chief Justice of India, he said so, that we would like to have artificial intelligence in our system as far as it is possible. Now, for deciding some of the cases which you mentioned, traffic challans and others, or sentencing, but sentencing also may not be that easy or safe insofar as India is concerned. I'll tell you the reasons. But there are certain disputes which where like MSMEs disputes, etc., where decision in the form of artificial intelligence can play a role. And I have seen, I had gone to China in 2018, was one international conference there, and I saw their artificial intelligence used in decision making of certain types of cases. But then it has to take an IIT Kharagpur, which you said, so for IIT, it is only from the point of view of, a particular scientific thing which can make the things easier. But when it comes to judicial system, we have to see, as I was now telling you, now two persons have committed same crime. Say it's theft, or it's murder, or it is dacoity. But when it comes to awarding the sentencing, even if in both the cases it is proved, I'm talking of two different, incidents, the punishment may be different, because it depends on so many other factors. What are the extenuating factors, mitigating factors, what are the other factors? So we are not on the sentencing as such. Now again, when it comes to, say, America or many Western countries, where the sentencing policy is, it's like arithmetic. This offense, for the first time, if you have committed, this would be the punishment. Second time, it will go up. Third time, it will again go up. But that doesn't happen in India. And there is a lot of criticism about what happens there, and there's a lot of criticism about Indian practice also, because then here it becomes the whims of the judge, in what way he thinks. So therefore, both have their, it's a topic which can be discussed at different level and different, but both have their own, really. So we are, but we are not concerned with that in today's topic.
Sir, so we can take 3 more questions. Keep the questions brief. And please, I'll also request the panelists to answer brief.
Good evening, panelists. I am Prakhar. I work at Shardul, Amarchand. So, considering that a lot of panelists discuss about how the civil litigation or commercial matters are affecting the economy, so do you think that because a law which is successful in Singapore may not work in India, so do you think that in future we can have a concept like a private court, where you can have experts, maybe on deputation basis, be judges for some time, deal with the commercial matter, so that it will lower down the pressure on judiciary as well, and the private players will have a a forum where these matters can be decided, just like doing Section 9 and Section 34 can go on to these courts.
Okay, I think major question put it well.
Tejas, is from your office, you give the answer.
No,
Isn't arbitration private court?
Yeah.
No. So what he's trying to say is that after the arbitration is over, you come back to the normal court and be in the queue with other cases. So that's not the idea. The idea for arbitration is that you go for a private dispute resolution, which is alternative to the main dispute resolution mechanism, which is court. Then why do you have to come and join the queue? Just what you're doing is, out of the 5 layers of judicial system, you are removing only one bottom part and replacing it with the arbitration, but the remaining are the same. Of course, the nature of those are not the same, as the challenge is not the same as the appeal. But definitely, if we are following Singapore model, you have the experts as the judges there. I have done so many arbitrations there where before even challenging, you have to pay for the security of the cost of the other side, in the sense that you have to pay for the lawyer's fees, which is quite high. And many times we say that don't challenge the award because we know the outcome, because we know the judges who are going to be there, because they are constant. Here, as sir said, 6 months the same judge is having an arbitration roster, and after that they are on the criminal side. We don't need to do that seriously, because in India, we identify locations where we have most of the seats of arbitration, have these courts who can deal with this. We can have international judges also. Like sir is a judge in Singapore International Commercial Court. Justice Lokur is a judge in Fiji, where there can be international judges also who are former judges of the other courts coming and presiding over those courts, and you really don't have to go to the normal court system for your alternative dispute resolution. That's the way I think I agree with your suggestion. We should have that kind of a system, which is not very difficult. Although we did a lot of research on specialist court, we need to amend the constitution to little extent, because of the writ jurisdiction, you cannot take it away. But apart from that,
That can't be amended.
that can't be amended also. So it's a basic
Ishwananda
structure.
Bharti is
So
very
that's
clear.
a basic structure issue. But you can definitely delegate other than the writ. So you can go to High Court
yes,
for writ. It's not about maintainability of the writ. It's a self-restraint of exercising the writ jurisdiction, which the courts are. Anyways, there are Supreme Court judgments now that in arbitration matters, it's a complete court and the writ jurisdiction should not be exercised. So I think this kind of system would really
another
help.
very interesting development as far as Supreme Court is concerned. Now, in arbitration earlier it was, when there's one party Indian, one party foreigner, you can choose a different jurisdiction. So German and Indian parties can go to Singapore. Now, Supreme Court has held even two Indian parties can.
PASL
So
case.
this is how we are now going ahead. So if you can choose the two different parties, so why not after the award, as rightly mentioned, a very good suggestion also that this system should be created.
Correct.
Good evening. So good evening. I am Milind from Khaitan, Khaitan & Co. For the panel in general, there are two parts question. One is about this thing which we talked about, having two Indian parties. If we meet the criteria as we talked about, the three pillars, be it the court, the laws and the institution, then also two parties may choose a seat outside India, Indian parties. So how can we counter that? And secondly, when it comes to institutional arbitration or even ad hoc for that matter, we have section 16 and all. But isn't the court lagging a bit when it comes to maybe, for example, group of companies? Now we have just referred it to a larger bench and everything. So how do we move ahead in that respect? That isn't court lagging, because till we are not sure of the parties who we mark in the as a counterparty, how do we move forward as an institutional arbitration? We have avenues and all, but that is a question which perturbs a lot of problem, creates a lot of confusion.
I'll request Vanita to take that question and answer one part of that question here, another part she can tell you in office, so that we can have another question. Thank you very much.
No, so that is why I think that we cannot do away completely with courts as far as group company doctrine is concerned. Now it's been referred to a larger bench. So to that extent, it's autonomy also. I mean, what you said about whether it can be outside, so that is what party autonomy is. I mean, they can always choose to have a seat. Yeah.
And, you'll find that there are always elements of something where the examination is required by the court. That may be a fraud, that may be a matrimonial dispute, that may be the certain types of disputes which have been identified. So in those cases, a complete elimination of courts may not be possible at some stage. And as you're right, in the beginning, how do you identify the in the layers of the companies who's involved, not involved at that stage? So that's the reason I think possibly at the 11, 9 or at some maybe at a 14 stage, somewhere court need to look into the certain aspect which possibly cannot be examined by the arbitral tribunal.
And in fact, where we are here today is also because of the proactive judgments of the court,
Yes.
which have led to these amendments and brought us here. Yeah.
So we actually have time for at least one more question, because we'll finish only one piece of
Yeah.
question.
Can I raise a question? I'd like to address this question
We'll take a question from you.
to Mr. Balbir Singh. My name is Atul Shivpuri, associated with the law firm, and we are on the panel of a number of public sector entities. My question is, and this is to answer, this is the doubts raised in the mind of Mr. Srivastava also, that why do we keep going to courts? I mean, we should dispense with the idea of going to courts when we have an arbitration tribunal constituted. When you have section 17 for interim measures of protection, and you are unable to enforce that order, so by force you have to approach under section 9 for seeking interim reliefs. Why can't the government or the legislator confer powers on a tribunal equivalent to that of a court? Because you see, when you go for enforcement of the interim orders, the state police or the other institutions do not accept that order. So we are forced to approach under section 9. Similarly, when you have a problem in the constitution of a tribunal, and there's a difference of opinion among different claimants and defendants, you are again forced to approach the court. So the act needs to be amended. Okay.
No, I think I agree, and Tejas said that I think it's more of a structural issue. that when the PSUs are operating, there is certain element of, I'll not say threat, but certain consideration in mind that a decision making is to come from the people within that particular organization, or there should be a central body which can take certain decision where there is no threat to the person who's taking decision. I agree on that part. I think that's one fundamental issue. I completely agree, and possibly if that decision making process is can take care of the decision being protected and not questioned, that can eliminate a lot of these areas where you need to go to the court. But I think that's more of a fundamental issue. In my experience, I can tell you I've seen that there are certain processes being created right now, like one committee which has been formed, and where in case of PSU, certain decision making, the arbitration, a clause, how it is to be drafted, what pool of arbitrator is there. I think there are some steps in that direction, but to say that to these legacy issues which are completely to be eliminated, where historically it is going on, the decision making when it comes to Section 9, let's say a property to be attached, nobody would like that not going to a court, before going to court somebody accepting the interim award given by the arbitrator. That issue will remain, I think, unless it is a larger level, some principal issues are taken. That's what my viewpoint on this is.
My question is, Justice Sikri sir, you very rightly said law and economics, they go together. And especially in infrastructure projects, there is a need because it's going to affect the public very largely. In that context, my question to anyone, in fact, Justice Sikri sir can throw light on this. There was a suggestion which was being made that we should bring in international arbitrators from outside, because that will enhance the reputation and transparency, etc. If India being a diverse country, we all know, with social, economic problems, etc., if outsiders, if they have to come, and without having understanding of the socio-economic problems of this country, how far effective that international players, in fact, will be in arbitration? Because ultimately, if the money has to pull back.
No, I think.
No, please go ahead. No, I couldn't understand whether you want international arbitration.
No.
Yeah, I
That's
was
what
going to
suggestion
say that.
was given.
I think this apprehension is ill-founded.
Yes.
Because when we are talking about the international arbitration, at the same time we are talking about international commercial disputes. So where's the question of Indian socio-economic things and all those? One thing, if you know, even under our Arbitration Act, Section 28(2) or 3 is very clear. The case is not to be decided on the basis of equity. It is a commercial dispute on contractual and in terms of the contract. And of course, along with that trade usage or that this is. So therefore, international arbitration, in fact, are decided on that basis only. So contractually, what are the, there's a contract which is entered into between two parties. So they are bound by that terms of that contract. So what are their rights and obligations under the contract? And on that basis, whether certain claims preferred by one party against the other are maintainable or payable or not. So on that basis, if international and people coming from other countries are also deciding, I don't think there is a problem in that.
Thank you, sir. Thank you.
Rights versus economic rights. Yeah. These are two different buckets. You can't mix these two.
So, thank you very much. We have had a very patient and indulgent audiences, especially as far as I am concerned. And thank you, IDRC, once again for allowing me to share this space with such legal luminaries. It's been a complete pleasure and privilege. So thank you very much. Thank you. Can we get the panelists again?
This discussion has brought much deeper understanding with a number of takeaways. Now I would like to request Mr. Divyan Chanurati to deliver the vote of thanks.
Thank you, Ria. It has been a pleasure and great learning hearing the insightful views of our esteemed panelists in the conclave Arbitrate in India, Let's Make Resolve in India reality. I am a firm view that the exchange of ideas that has happened today's conclave, will reap long-term benefits for the field of arbitration. Ministry of Law and Justice, Government of India has requested the conclave report that shall be prepared by the IDRC along with our knowledge partner NLU Delhi. We are sure that the views expressed and concerns shared today shall have a positive bearing on the arbitral environment. I am highly grateful to Hon'ble Justice Sikri for always being there for us and inspiring us in many wonderful ways. My sincere thanks to Balbir Singh sir, Additional Solicitor General of India, Tejas Karia sir, partner Shardul, Amarchand, Mangaldas, and Vanita Bhargava ma'am, partner Khaitan and Co. for taking time out of their busy schedules and gracing the conclave, which marks completion of 2 years of establishment of Indian Dispute Resolution Center. My special thanks and regards to our esteemed moderator, Sanjeev Srivastava sir, senior journalist and former head of BBC India. Thank you, sir, for coming all the way from Jaipur and blessing the event to make it a huge success. Now, I would like to thank our supporting organization, without whose support this conclave would not have been successful. I would like to thank Shardul Amarchand Mangaldas, Khaitan and Co., Ratan India, OP Jindal Global University, Torrent Pharma, Banksay, SNG and Partners, TrademarkClick.com, Telecommunications Consultants India. I would like to thank our knowledge partners NLU Delhi, Vivekananda Institute of Professional Studies, Galgotia University, Indian Institute of Arbitration, Indian Institute of Mediation. I would like to thank our media partners for covering today's conclave, India News, NewsX, India Legal, Haribhumi and Janta TV. I would like to extend special gratitude to our respected Board of Advisor members Sanjay Rathi sir, Tanmay Mehta sir, Rashmi Gogoi ma'am, Satish Daya sir for their constant support and guidance. I would like to thank Mohit Gupta sir of Expression 360 and his team for helping us organize this conclave. I would like to thank Sri Manoj Sharma sir, our IT head and his team for working tirelessly to develop the IDRC's EADR software, website and our cloud infra. I would like to thank our team members, Sheetal June, Sunny Chikara, Akash Kashyap and Kamal Singh for their hard work. Without this conclave would not have been successful. I would like to thank our esteemed guests and audience for joining us today at the conclave. We are highly obliged to have you with us today. I would like to thank India International Center, their staff, service providers, and the Delhi Traffic Police. With this, we conclude the Arbitrate in India Conclave 2022. We look forward to see you all at our next edition of the conclave. May I now request the esteemed panelists and guests to join us for the cocktails and dinner. Thank you. Enjoy the evening. Thank you.
Thank you,
Thank you, sir.